Sarah Lindstrom was a consumer protection attorney whose career had been built on dismantling predatory collection agencies, fraudulent financial practices, and systemic violations of federal statutes designed to protect ordinary citizens. She possessed an encyclopedic knowledge of the Fair Debt Collection Practices Act, FDCPA, a law intended to curb abusive, unfair, and deceptive debt collection practices. She had always viewed her own HOA, the pristine and tightly controlled Amberwood Preserve, as a quiet retreat until the board, under the direction of its management company, Sterling Property Services, decided to target her over a minor arbitrary dispute. The conflict began with an aesthetic fine. The HOA alleged her backyard bird feeder violated the accessory structure visibility clause, levying an initial $50 fine. Sarah immediately disputed the charge in writing, citing the specific CC&R section that exempted temporary mobile structures. Sterling Property Services, however, ignored her detailed dispute letter and instead initiated a campaign of aggressive harassment. The phone calls started immediately. Repeated calls to her home phone before 8 a.m. and after 9 p.m. Automated, pre-recorded messages demanding immediate payment and threatening legal action. And a rapid-fire sequence of threatening letters printed in stark red ink, which falsely claimed the debt was past due by 90 days and warned of imminent credit reporting and foreclosure proceedings. For an ordinary homeowner, this calculated, high-pressure collection strategy would be terrifying. For Sarah Lindstrom, it was a profound professional revelation. The moment she received a letter from Sterling Property Services stating, "Final notice before referral to collections," she realized the legal loophole. Sterling Property Services was not acting merely as a manager. It was acting as an unlicensed, aggressive third-party debt collector under the legal definition of the FDCPA. The FDCPA generally exempts the original creditor, the HOA itself, from its rules, but explicitly applies to any person who uses any instrumentality of interstate commerce or the mails in any business that principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect, directly or indirectly, debts owed or due or asserted to be owed or due another, Sterling, as a separate entity collecting debt on behalf of the HOA, the creditor, fell squarely into the latter category, particularly given their aggressive and automated collection schedule. They were operating in her community like a miniature, unregulated collection agency. Sarah compiled her evidence with the systematic discipline of a prosecutor preparing for trial. She used her phone's call log to document the prohibited early and late calls. She recorded the content of the threatening pre-recorded messages and saved every single abusively worded letter, noting that they failed to include the legally required FDCPA validation notice, a boilerplate provision Sterling had neglected because they assumed FDCPA law didn't apply to them. She documented multiple specific violations: prohibited communication times, $1,000 per instance; false threats of legal action credit damage, $1,000 per letter; and failure to provide validation notices, $1,000 per letter. She didn't write Sterling a cease and desist. She filed a federal class action lawsuit in U.S. District Court, naming both Sterling Property Services and the Amberwood Preserve HOA as defendants. Her complaint was a masterpiece of consumer law, alleging systemic violations of the FDCPA, coupled with claims under the state's stringent Consumer Protection Act, CPA, for unfair and deceptive practices. The lawsuit didn't seek to merely invalidate the $50 fine. It sought statutory damages of $1,000 for every single documented violation, plus all attorney's fees on behalf of Sarah and every other resident who had been similarly harassed by Sterling's automated, aggressive collection tactics over the past 2 years. The legal shockwave that hit Sterling Property Services was immediate and devastating. The HOA's general counsel, focused only on local covenant law, was blindsided by the federal filing. Sterling's corporate counsel quickly realized the catastrophic liability they faced. If they were ruled to be a debt collector, their massive automated and standardized collection system, which they used across hundreds of HOA communities nationwide, was likely committing tens of thousands of FDCPA violations, potentially leading to millions in mandatory statutory penalties. During the expedited discovery, Sarah deposed Sterling's CFO, forcing him to admit that Sterling's core business model generated significant revenue from late fees and collection costs on behalf of HOAs, proving that debt collection was a regular part of their business, thus confirming their FDCPA classification. Sterling Property Services knew they couldn't risk a federal judgment that would set precedent for their entire national operation. They immediately moved to settle. The final settlement, executed under federal judicial decree, was a total victory for Sarah and the community. First, Sterling Property Services was ordered to immediately pay Sarah Lindstrom a massive, undisclosed settlement covering her statutory damages, easily exceeding $50,000 for her extensive violations, and all of her extensive attorney's fees. Second, Sterling was mandated to cease all debt collection communication with Sarah and the Amberwood Preserve HOA, and to permanently modify its collection practices nationwide to comply fully with FDCPA guidelines, including providing all required validation notices and adhering to communication restrictions. Third, the original $50 fine against Sarah was permanently waived and dismissed with prejudice, and the HOA was compelled to issue a public apology to the community regarding the management company's abusive tactics. The management company, forced to overhaul its entire collection process due to the massive legal risk exposed by one sharp consumer protection attorney, immediately lost a huge stream of revenue from improper fees and abusive fines. The company's aggressive, predatory model was permanently neutralized by Sarah's strategic use of federal law, proving that even the most powerful HOA management firm is not above the Fair Debt Collection Practices Act.